Welcome back. Now we're going to talk about exhibits. To see sad sights moves more than to hear them told. To paraphrase Shakespeare from The Rape of Lucretia. When I think about exhibits, I begin as an evidence professor. I think about it from the standpoint of how do I get it admitted. And in order to truly understand how to admit an exhibit, you've got to know what the thing in question is and the purpose for which you are offering it at trial. Evidence broadly falls into three categories: real, testamentary, and demonstrative. Real evidence is exactly what it says. A gun, a knife, DNA, a contract, potentially. Each of those things has existence in the real world and is tied to an issue in a trial. Real evidence also divides into two subcategories: fungible and non-fungible. I want us to think of the classic example of a bloody knife. The knife itself has distinguishing characteristics, either in the blade or the handle or the markings on it, sometimes maybe even a serial number. Because it has distinguishing characteristics, in other words, I can look at it and pick it out from other knives that are similar, it's non-fungible evidence. And non-fungible evidence, we're not worried about it being adulterated or modified. So we don't need a chain of custody document with it. We don't need to treat it in a particular special fashion to ensure that it is what it purports to be. Because we want to be able to rely upon this evidence as being valid when we get to trial. So the knife is non-fungible. We can lay a foundation. We use the cop who picked it up at the scene, or the person who put it in the evidence locker, or the individual who owned it. The blood on the knife, on the other hand, is fungible evidence. That's DNA evidence of perhaps someone who'd been stabbed by that knife. I can't look at that blood and separate it out from any other blood sample. And because it can be adulterated, because it can be modified, and we wouldn't know, from the moment it comes under the control of the relevant authority, it must be properly documented with a chain of custody. So that's why when we admit fungible evidence as an exhibit, we have to have a chain of custody document that goes with it. So fungible evidence is a two-step evidentiary and authentication process. The piece of evidence itself that you had tested and you're going to enter the test for, and the document that accompanies it showing how we safeguarded that evidence in the intervening time. This means that the foundation for real fungible evidence is different from the foundation for non-fungible evidence. Non-fungible evidence, it's usually sufficient to say, is it in the same or substantially the same condition as the last time you saw it? And that'll get it admitted as long as you've established relevancy. If you've gone through authentication, you've shown that it is what it purports to be, sufficient that the judge believes you made it admissible, you're good to go. Fungible evidence, I not only have to show that it is what it purports to be based upon my observation, but that I properly safeguarded it all the way through the process. When you think about fungible evidence, think DNA, think blood tests, think drug samples that have been tested by a laboratory. Anytime I have to send something off and have a scientific process applied to it so that I can determine whether or not it's relevant, in all likelihood, I'm going to have a fungible piece of evidence. The second category of evidence is testamentary. That's written documents that you may be offering for some sort of legal import. Why are testamentary documents different from a foundational perspective before I can use them as exhibits? Because I have to have a hearsay exclusion or exception before I can show them. This means that your knowledge of hearsay is crucial when dealing with testamentary exhibits. And so if you take, for example, the sworn statement of the plaintiff in a case and the plaintiff's being cross-examined by the defense. The statement of the plaintiff is admissible as an admission by a party opponent under Federal Rule of Evidence 801. The publication of that exhibit, after it's been properly admitted and identified, you publish a copy. And you can publish a copy by putting it up on the screen. You can publish a copy by blowing it up as a larger document. The exhibit itself might be Defense Exhibit Alpha. The blow-up would be Defense Exhibit Alpha 1. Because that blow-up, if I have any other witness look at it, if I have any other witness modify it by marking on it or circling words, that's demonstrative evidence. Because it's demonstrative evidence, it doesn't go back to the jury. And then the final category is demonstrative. And when we admit demonstrative evidence, it's to assist the jury in understanding the witness's testimony. And I believe Professor Rose will talk with us about some of the foundational ways that we make that sing within the courtroom.
When we're dealing with evidence and we're laying the foundation in front of the court in order to admit the document, we need to make sure that we cover the foundational requirements. Witness, do you recognize what I am handing you? How do you recognize it? And then this last question is dependent on if we're dealing with the actual item itself or a copy of it. If the actual item itself is in the same or substantially same condition as the last time you saw it, if it's a copy, is it a fair and accurate copy of that? Or if it's a photograph, is it a fair and accurate depiction? What we want to do is make sure that we have that foundation clear so that then once we get it in, we can ask the witness a key question. Would it aid the jury in understanding your testimony if you were to step down and interact with an enlargement of that exhibit? Let's say, for example, a diagram of a scene of a crime. The witness says yes, you turn to the court. Your Honor, the witness has testified that this will aid the jury in understanding their testimony. If they step down, may they do so. You want to make sure you take the time to practice this with your witness beforehand, both in your office and, if possible, in the actual courtroom that they're going to be doing it in. You want to make sure that you know what hand they write with so that you can position them accordingly so that when they turn in order to write on the document, it's natural and you don't have that awkward moment when everybody's futzing with things. And then as you are having them mark up the document, witness, show me where you were standing within the restaurant on the night in question. I was standing over here and I'm indicating it with an X. You have two choices at that point. You can either, in order to preserve the record for any kind of appellate issue, let the record reflect that the witness is marked on the diagram in the southwest corner with an X, which gets a little tedious and cumbersome, or with your next question can do the same thing. I see you've marked an X in the southwest corner of this diagram. As you're standing in the southwest corner of that restaurant, what, if anything, do you see? Then, once the witness has completed answering all of the questions, I like to have them initial it in front of the members of the jury to show that all the marks that they have made have been true and accurate as to their recollection. That does not mean you are admitting it into evidence. This is demonstrative use only. Once I've had the witness finish interacting with the document, which I may have had them had some breaks where they have mimed some things out for the jury so the jury can get the physical expression of what has occurred, I'm going to turn to the judge and ask that the document, the exhibit, the demonstrative, be preserved for closing argument and that opposing counsel not mark on it. The reason that I'm doing that is I want to bring it back up and close so that I can put the jury in that courtroom, in that scene, and say, we talked with Officer Anise Baxter White. She told us about the bullet holes that she found and she marked them for us here on this diagram, members of the jury, and walked them through that. The reason you want to be clear about where the witness is marking out loud is because the court reporter cannot take down where the witness is marking things. And you need that record to be clear. So when the appellate attorney gets your case, they can point back to that as part of the argument as to why you were successful and why your side should maintain the victory that you have earned in that trial. Step downs are a great way to break up what can otherwise be the monotonous process of direct examination, but they need to have a point and they need to be worth the time of getting the witness off the stand, standing in front of the members of the jury and interacting. It's not enough for them to come down and simply circle one thing, okay? We want to make sure that we are using them appropriately and efficiently so that we can use that visual element to really heighten the work that we're doing with the direct examination.
When we think about the step down and the admitting of the demonstrative age, you need to know the court that you're in. For example, in federal court, they may expect, Your Honor, we offer Defense Exhibit Alpha 1 into evidence for demonstrative purposes only. Some jurisdictions require that offer as opposed to preservation. Other state jurisdictions merely ask that you preserve it for closing argument. Both are factually and legally correct. You just need to know that local rule of court so that it flows with the judge, and you don't have one of those cognitive breaks where the judge is thinking about something other than how well you're representing your client that particular afternoon. Well, that covers the fundamentals of exhibits. We'll move on to the subject of cross-examination now. See you down the road.